Hey, thank you all. So the first order of business is to elect a chair of the Licensing Statutory Subcommittee for the year. May I please have nominations for the chair?
I'd like to nominate Keith Horgan, please.
Thank you. Seconded by Councillor Wilson. Councillor Horgan, you happy to accept?
I'm honoured, thank you.
Thank you. I'll hand the meeting over to you then.
Thank you, Leah. This is the Licensing Statutory Subcommittee on Friday the 7th of June 2024. And I'll start, if I may, with item 2 on the agenda, which is apologies and substitutions.
Thank you, Chair. I've received apologies from Councillor Lavinia Edwards, who's substituted by Councillor Martin Goodall, and apologies from Councillor Charlotte Kane, who's substituted by Councillor Gareth Wilson.
Thank you. I now ask if anyone has any declarations of interest in any of the matters on today's agenda. There appears to be none. So I'll move on to the most important part of this agenda, which is item 4. Just before I do that, obviously the hearings of the Licensing Statutory Subcommittee have a specific procedure, details of which are available here, which nobody can read on the camera, obviously, but in the interest of time, I don't propose to go through them in any great detail. And they're also on page 3 of our papers for today. There are no deviations from the specific procedure other than there are no representations from the applicant or any of the parties other than the committee who's sitting here, myself, Keith Horgan as chair, Councillor Gareth Wilson and Councillor Martin Goodall, who are members of this committee as well. And from Democratic Services, Leah Mickleborough and Cameron Overton. And representatives from our legal team, Maggie Camp and Angela Tyrrell. And our licensing officer, just in case anybody wondered if he was indeed the applicant, which he is not, Stuart Broom has decided to present the case today to us from the public gallery, at which point I will do no more than to hand over to Stuart to take us through this item. Thank you, Stuart.
Thank you, Chair. Yeah, sorry to confuse. I just thought it'd be easier to sit opposite you and all in a line. Now, as you pointed out, there's nobody here representing the applicant and nobody here representing the responsible authorities. That's because they have all agreed conditions between themselves and they've agreed to dispense with the need to hold a full hearing. Under the Licensing Act, when there are still representations submitted and not formally withdrawn, discretion to authorise and determine the licence cannot be made by myself under delegated powers, which is the reason why we're still here to have a kind of a closed hearing for members to determine the agreement that's been reached. So without further ado, I'll start with the report. I will go through it sort of fully for the purposes of obviously those who are perhaps tuning in remotely to observe. So the issue today is for members to determine an application for the grant of a new premises licence in respect of RBF Festivals Limited. It's going to take place on part of Harlock's Farm, Soham Road, Stuntney, just behind the Ben's Yard complex, just so members are aware. So the background to this is that on the 28th of March 2024, RBF Festivals Limited applied for a premises licence under Section 17 of the Licensing Act to licence a piece of land behind Ben's Yard on Soham Road, Stuntney. Now that's Appendix 1 to the report. The application was served on the responsible authorities and advertised in accordance with the regulations of the Licensing Act, and officers can confirm that all that happened correctly. The application form states the applicant intends to use the licence to cover licensable activities at their event known as the Cambridge Rock Festival, which takes place over a 4-day period, typically held the first weekend in August. To support this, the applicant has requested the information in Table 1 of the report, which is, in summary, alcohol for consumption on the premises, Thursday to Sunday, 11 a.m. to 11 p.m. Late night refreshment, so that's sort of hot food and drink sales from 11 o'clock to 11:45, Thursday to Sunday. Live music and recorded music indoors and outdoors, Thursday from 5 p.m. to 11 p.m. and Friday to Sunday, 11 a.m. to 11 p.m. With the opening hours of the site being Thursday to Sunday, 11 a.m. to 11:30 at night. The applicant offered steps that they're willing to take to promote the licence and objectives, and they can be found in Appendix 2 to the report. It just outlines the steps that they felt promoted the licence and objectives. The plans can be found at Appendix 3, and an area plan sort of showing just a sort of a larger scale it can be found in Appendix 4 for members' benefit. Now, during the consultation period, the licensing authority received 2 representations from responsible authorities, namely Environmental Health, both the domestic team and the commercial team that look at nuisance and public safety issues, respectively. And the full details of those objections can be found in Appendix 5. No representations were received from other persons permitted by the Licensing Act to submit representations. So they're people, it could be residents, councillors and other sort of parish councillors, people like that. And no other responsible authority representations were submitted either. Now, at the time of publishing the report, in accordance with our requirements, there was no agreement reached between all parties, but in the period between then and now, agreement has been reached, and I'll explain that to members shortly. Now, members are obliged to determine this application with a view to promoting the licensing objectives, which are the prevention of crime and disorder, the prevention of public nuisance, public safety, and the protection of children from harm. And in making a decision, members are obliged to have regard to the statutory guidance issued under Section 182 of the Licensing Act 2003 and the Council's own statement of licensing policy. Should you depart from either, you must specify your reasons for doing so, and members must take into account the information contained within the report and any evidence, say, that's given verbally as well. But obviously, as members are, the applicant's not here, then that's not going to be the case today. It's paragraphs 4.2 and 4.3 just are to point you direction of the relevant statutory guidance considerations, which obviously you've had a chance to read before today. And members can determine this application as follows. You can grant the licence subject to the conditions that are consistent with the operating schedule accompanying the application, modified to such extent as members consider appropriate for the promotion of the licence and objectives. And obviously it will be subject to any mandatory conditions that must be included in the licence. You can exclude from the scope of this licence any of the licensed activities which the application relates, and you can refuse to specify the person on the licence as the designated premises supervisor, or you can reject the application. Now, you may not modify or impose conditions or reject whole or part merely because you consider it desirable to do so. It must actually be appropriate to do so in order to promote the objectives, and any step must be relating to an actual representation made. Okay. Conditions attached must be focused on matters which are within the control of the applicant, the premises and its vicinity. And Regulation 19A requires you to ignore information that is not relevant to the application or the representation that's been submitted. Any decision must be taken as appropriate and proportionate to the objective being pursued, and your attention is drawn to Article 6, right to a fair hearing, Article 8, right to private and family life, and peaceful enjoyment of possessions under Article 1, which can include a licence. Okay, financial and legal implications. There is a cost to convening these sort of hearings, but that's included in with all the application fees that come into the licensing authority. And anyone who's a party to the application can actually appeal the decision of a subcommittee. And obviously, if that was to occur, then further costs could be incurred from that. Now, it brings me to the agreement that has been reached between all parties. Members should have seen this additional piece of paper, and it's a very minor change to what was actually submitted, but essentially it reads that a premise license holder shall give notice of any event dates together with the proposed licensable activities and timings permitted for events beyond September 2024, where the number of attendees is greater than 499, and do this no later than 3 months before the date of the event to the Council's licensing authority and the Safety Advisory Group. The notice will include a draft version of the event management plan for the declared event. Condition 2 is the premises licence holder shall submit the draft agreed version of the event management plan to the Safety Advisory Group no later than 28 days before the first day of each declared event. The final version of the event management plan must be agreed by the licensing authority and Cambridgeshire Constabulary no less than 7 days before the first day of the event. And it should comprise of, but not be limited to, details such as the site plan showing locations of fencing, bars and entertainment areas, details of security, including fencing, stewarding arrangements, details of event hotline, should neighbours wish to contact the organisers, noise monitoring procedures, including management and control measures being in place, traffic management plan, major incident plan, security and crowd management plans, medical risk assessment plans, adverse weather plan as well. And I am aware members may sort of consider why after September 2024, and it was just purely because the process for the event that's going to be occurring in August 2024 is already underway, and so it made sense for the conditions to be applicable from September 2024. But as I say, the process with the Safety Advisory Group has been occurring in anticipation of this licence hopefully being granted. And I am aware that environmental health have been satisfied with the event management plan that's going to be in effect for the event occurring prior to September 2024. That's the end of my report, Chair. If I have any questions, I'm happy to answer.
Thank you, Stuart. Please convey our thanks to the 2 officers that achieved the changes to the applicant's submission, and thank you also personally for just reminding me that the reason why 499 attendees is a relevant number as opposed to the original number, which was above 2,000, and that's for those who may be watching on camera, the difference between whether you need to apply for a temporary event notice or a premises license, and the threshold being at the 499 attendees number. So without any more ado, I would now invite members of the committee to ask questions of the licensing officer. Gareth, your hand went up first.
Thank you. Sorry, how near is the nearest residential house to this site? Because it's fairly isolated, this site, isn't it? And nobody lives in Ben's Yard, do they?
No, so no, Ben's Yard is commercial. The landowner of Ben's Yard is the landowner of the land that is being requested for this event. The nearest places in the map in Appendix 4, you'll see where the red line has been drawn around the site, and you'll see Leys Clark Farm and then the Harlocks Farm and the Old Hall. But the people involved in Ben's Yard are involved with the Old Hall, and obviously they're in full support of this event happening on that field. So as far as the nearest sort of resident, I think approximately about 1 kilometre from the site. As you said, Councillor, it is a very sort of remote location, and as I say, they would have seen the notices on the property, there would have been a notice in the local paper as well, and obviously on our website via public access. And we had no representations from any of those residents.
Can I follow it up? And I assume that the people at Ben's Yard are keen to have this because it produces a whole lot of extra possible customers for them.
I imagine that, yes, it will have those additional benefits. I would argue as well that, events of this scale, have additional benefits to the area generally. People potentially coming into the stations, the railway station just down the road and getting taxis from there, so there's potential for financial benefit to many sort of areas.
I have a couple of questions. As I said earlier, I'm very pleased that they've agreed to the changes to adjust the threshold to the 499 number. I move on to item 2 on that revised list about the 28-day and 7-day notice period, and bearing in mind, obviously, our desire for the prevention of crime and disorder, public nuisance, etc., public safety and the protection of children from harm. Obviously, the event management plan and associated documentation and its contents, very important. And you obviously have great experience as to whether or not the 28-day and 7-day periods are sufficient time for those relevant parts of the process. Is that enough time?
It is enough time from a licensing authority point of view, because the process has the initial draft documents 3 months, at least 3 months before, and then obviously the final version 28 days before. We do feel, certainly from my conversations with environmental health on this, they were satisfied that it was enough time for them to do what they needed to do for this type of event. Being that it's a one-off 4-day, license that's being permitted. And from our point of view, we will just have to read through the document and agree it. And yes, so in answer to your question, 7 days will be sufficient for us to do what we need to do.
And in the event that they don't provide it with at least 7 days notice, you do have the ability still to tell them not to hold the events. Is that correct?
Yes, Chair. Basically, if they failed to comply with any of the conditions, but certainly these conditions where perhaps they didn't give the draft document till 2 months before, it would be a technical breach of the license, and it would render any authorized activities as being unauthorized. So yes, we would be able to, take action should the need arise.
Excellent, thank you. Going to just drill down a little bit now and appreciate that what we don't have are copies of the event management plan and the security and crowd management plan, etc., etc. But I'm looking on page 30 of the paperwork where it says that they will ensure adequate music noise level controls are maintained. Could you just help us understand how that's achieved, generally speaking? I mean, I know it's somewhat subjective and very much a judgment, but how does that happen in reality?
On this particular site, from the most recent email I've seen from environmental health, you have to appreciate obviously that my area of specialty is not noise, but from seeing the emails coming in, that there will be people there with monitoring equipment that will be ensuring that throughout the entirety of the event that levels do not peak outside of the levels that have been agreed within that event management plan. Sort of elaborating again more on that, is there are those set conditions 1 and 2 that's been agreed. The event management plan itself becomes conditionable. So anything within the event management plan that is signed off, should the organizer not do those undertakings, then again, that would be considered to be unauthorized and action could be taken. All of these events have a debrief afterwards. where any sort of minor or major issues can obviously be addressed for two reasons. You know, obviously to see whether there is something that actually should be actioned from an enforcement point of view, but secondly also to obviously make sure that future events learn from, you know, things which have occurred.
So decibel meters, for example, would be available for use.
Decibel monitoring as opposed to limiting. Those sound limiters tend to be fairly ineffective, is my understanding, but the actual proper decibel calibrated machines to sort of test levels and constant monitoring throughout is my understanding of what will happen.
Thank you. I'm moving on to item 7 on page 30, where it talks about the SIA security. Says we have taken advice from our previous security providers on SIA staffing numbers. Now, obviously, the success of the event is going to depend on whether they get that the numbers right. Do we ever give any guidance on that? Who's responsible for saying, well, that's not enough people? You know, if they had, like, we can have one security guard there for 500 people over 4 days. You know, what guidance? Who's responsible for checking that? And do we give them any good guidance?
So the Safety Advisory Group is made up of representatives from responsible authorities under the Licensing Act, but also sort of public authority figures in a wider sense. So you'll have people in operational level at the police will be there. You'll have ambulance service, various sort of blue and green light services, as we'd call them, are present at those meetings. And whilst the Safety Advisory Group as a collective doesn't have an authorised sort of any sort of power as such, what they have is obviously a great deal of knowledge, and they have their own powers to take action under their own legislation should they need to, such as the police being able to put a stop notice on the events and things like that. So the knowledge or the advice goes from that group of people, and they will assess the event management plan. They will look at the numbers. They will look at the points of egress, you know, and access. So each site has its own specific sort of parameters, really, of operation. And whilst this event is an event that is established, it's been run successfully in Cambridge. I think it's actually in South Cambs area previously, but it's been located over towards Cambridge, and it's relocating. So they are essentially transferring a known successful event to our area. So when they're sort of talking in this document saying that they've had this previous, they're not starting from scratch. So they will have an understanding, and they will present in the draft event management plan what they believe the numbers are required for, you know, to take into account the number of stages they're having, the number of access and egress points that they're going to have. And then that information will obviously be part of the SAG discussions. And at that, they will then say, well, we're not quite happy with this. We think your numbers are too low in this area. We think you should have more, you know, stewards or first aiders or whatever it may be. So that's how these sort of event licenses go through the process and get their advice.
Thank you. I'm sure that was the case, but I just wanted to make sure that a knowledgeable eye is run over the plans and the numbers. And I presume, and I'm looking on page 32, item 23, that would go for body-worn cameras as well. That because when I've circled the word some, as in some designated SIA security personnel would wear it, and I, you know, raised the question in my mind: is some? What is that? Not most, not half of, or whatever. I mean, not knowing how many SIA security personnel are going to be there in total, but just raised a question mark in my mind. But as long as a knowledgeable eye is cast over the plans and the numbers, I'm happy.
Indeed, Chair, and there would be, again, I'm only assuming here, but it's possibly that they're looking at in areas where maybe they're looking for back searches and things like that, that the body worn will be used, but it won't be used everywhere, possibly in a way of being proportionate regarding, you know, privacy issues and things like that. But absolutely, there will be knowledgeable people who will cast an eye over this event management plan, you know, before it presents itself to ourselves as licensing.
Thank you. That's all my questions satisfactorily answered. You'll be pleased to note.
Additional question. If we approve this application, does it give IBF the right to hold this every year in August, or perhaps if they want to in January or some other thing? What rights are we given? Not just the one event, is it?
No, councillor. It is a 4-day event for a license that will remain in force unless it's surrendered or we revoke it for wrongdoing. So it will remain in force forevermore. It will give the rights to a 4-day event. As I say, that is likely to always be sort of last week of July, first week of August, that sort of summer event period, but it will never be more than a 4-day event. It will always have to go through this, through the conditioned requirements if there's more than 499 people going to be present. So there'll always be the sort of ability for us to not sign it off, effectively rendering the event unauthorized. So there is that safeguard there, but it's like many other licenses we issue with these premises licenses. They remain in force. You know, there's very few that we get that are in force just for the duration, and then they naturally expire. You know, there's obviously they're a great cost for the applicant to go to get one of these licenses, and if it's something they intend to do year on year, they don't tend to you know, put in a time restricted license.
Councillor Goodall.
Thank you, Chair. On that note then, Stuart, does the SAG then review what happened this year before next year's event happens?
Yes, councillor. So as I say, after one of these events, there is usually sort of a default debriefing meeting where we just sort of take stock of what happened, and you know, we can see whether there were any incidents that occurred. But each time the event is held, they have to go through this safety advisory group process, and yes, they will obviously, you know, bring the event management plan that was from the previous year to the table. But obviously if over time the number increases from 2,000 to 5,000, for argument's sake, that will change the parameters of those discussions, because obviously SIA people, you know, number of toilets, all these different factors, they will all change. So the licenses are designed to be a dynamic document that can take into account future changes whilst promoting the objectives, and obviously protecting those few, in this case, those few local residents that are there, but also, you know, the greater harms that can come from a very disorganized large scale event.
Thank you, Stuart. Anyone else have any questions to the licensing officer? No? Okay. Now, normally at this juncture, we would have the applicant perhaps presenting their case, and then questions could be asked of that person. Any responsible authorities could present their case, etc., etc. In this particular instance, because of the fact that prior to today's meeting, the conditions that need to apply have been agreed, those people aren't represented here, so therefore they can't present their case. They don't need to. It's a written submission effectively now, and so therefore we won't be asking questions or asking them to present their case. So we will come to the point now where there isn't anybody to present their closing statements as such, unless, Stuart, you have anything further to add?
No, I can close by saying that obviously we've assessed the agreement to ensure that no other parties are prejudiced as a result of the agreement who, you know, may have wished to make an objection should they have seen that agreement right from the outset. No such prejudicial sort of impact has been identified from the agreement, and the agreement is more restrictive than the original application that came in. So officers are content with the agreement that which has been reached.
Thank you, Stuart. Normally now I would close the session and we would retire into a closed session to make our decision. I'm happy to close the official part of the session so that we can make our decision, but I don't believe that unless anybody tells me otherwise, is there any need to go into a closed session to have a debate?
No, I think we're happy with it, don't we?
So if anyone else wishes to make any statement or representation, please do.
Thank you, Chair. What I'd like to say is because all parties have now agreed and they fulfil all the applicants' criteria and there's no objections, I can't see any reason why we can't grant this license. Thank you. I'd like to propose that we grant this license.
I'd be very happy to second it. Seems that they're quite an efficient organisation and with lots of experience. So, because they've been going for many years, haven't they? It should be a benefit to East Cambridgeshire, I should think. So I'm happy to second that.
Well, in that case, then I think it only relies on me to make to vote. But even if I voted against, which I'm not, I would be outvoted 2-1. I'm pleased to say that the decision is unanimous in favour of the applicant, Stuart. So if you can notify them accordingly, we would appreciate that. And unless there's any other further matters that anyone else wishes to bring forward at this time, I will now officially close the entire session. Thank you very much indeed today. Thank you.